Welcome to episode 10, season 3 of the Community First podcast. This podcast aims to reach out to the community by discussing legal and social issues to make the community a better place. In today's discussion, Demystifying transmission of shares in Ghana, I have with me my colleagues from the firm BNP Associates, Audrey Nana Oye Addy and Jennifer Melody Fynn Asiam. They are both legal associates at BNP Associates, and we will be digging into the matters of transmission of shares in Ghana. This issue is very important, but hardly do you ever hear people talk about it. So, come with me and let's delve into this matter. Audrey, you look ravishing.
Thank you.
You are welcome to today's episode.
Thank you. It's a pleasure to be here.
Melody,
Hi, Olga.
you are welcome to today's episode as well.
Thank you very much.
And I can see you are very prepared for this.
Very, thank you.
Okay. So, as I said earlier, we will be talking about transmission of shares. Already, I have mentioned transmission of shares for about 3 times already. So I'm sure you are wondering what transmission of shares are. We will get into that. But first of all, companies do raise funds through debt or equity. What is equity then? Equity is when shares are issued to shareholders for a consideration, either in cash or in kind, or otherwise than in cash. These shares become the personal properties of the shareholders. Hence, they have the right to transfer ownership from themselves to another person. That leads me to my first question. Melody,
Hi, Olga.
what is transmission of shares? With the understanding that shareholders can transfer their shares from themselves to other people.
Okay, thank you very much for the question. When we talk about transmission of shares, it's basically a process whereby the shares of a company passes on from one person to the other by operation of law, rather than the shareholder voluntarily transferring the shares to another person. So a share transmits by operation of law in situations such as the mental incapacity of the shareholder, bankruptcy, and death, which is the focus of our discussion today.
Right. Yeah. So as Melody mentioned, we will be really focusing on transmission of shares when death occurs. Right. So you have talked about transmission of shares being the change in ownership as a result of the death, as a result of the court issuing an order or bankruptcy of an existing shareholder to another person. Right. But
Sure.
how is that different from share transfer or share issuance? Audrey, would you take that?
That's great. I will. So basically, with respect to a share transfer, it's a private transaction where an already existing shareholder enters into a transaction with a third party to voluntarily sell his shares to the other person. It can probably be by way of a gift or by way of a sale. However, we must emphasize, or we must all note the fact that in some instances, the company's constitution may impose some restrictions on the transferability of shares, or even in the shareholders' agreement. But generally, a transfer of shares is a voluntary transaction subject to any other restriction that may be available. The shareholder, a pre-existing shareholder, is free to just transfer his shares to a third party for any other consideration as may be agreed between the shareholder and that third party. So basically, if you look at that as compared to a transmission of shares, mainly with a share transfer, it's a voluntary act. Shareholder willingly wants to just sell off his shares in the company to another person.
Oh, okay. So it looks like the transmission of share is an involuntary transfer, whilst share transfer is actually voluntary, where the shareholder can decide to give his shares out.
Yes,
if
in
that's
that way,
what you
yeah.
mean. Right. So then it leads me to my next question. In the case of death, like our topic depicts, is the beneficiary automatically recognized by the company? Because once the person dies and there's a will, right? The beneficiary's name is listed into the will. Does the company have to just recognize the person that, okay, since A is dead, you are now the beneficiary, so automatically you are the shareholder?
Okay, I think that's a very important question, and that's something that we encounter daily, or it's a practical scenario that occurs in our daily lives. Basically, with the transmission of shares upon the death of a shareholder, when a shareholder dies, the only persons who may be recognized by the company as the shareholder of the company are the personal representatives of the deceased shareholder, in which case could either be the executor where the person died leaving a will, or the administrator where the person died without leaving a will. These people are the legal representative of the deceased shareholder because they are the persons in charge of administering the assets of the deceased shareholder in accordance with either the will or the PNDC Law 111, that's the Administration of Estates Act, basically. However, before such recognition can validly take place, the executor or the administrator must take steps to notify the company by presenting the requisite documents to enable the company to verify the person's authority. That is the first step. So once the shareholder dies, the persons who may be recognized are the legal representatives, in this case, the executor or the administrator, who, upon submission of the requisite documents to enable the company to actually confirm whether indeed this person is the proper person, the proper legal representative to be recognized in the first place. So that's the first thing that must be done.
Okay. So after that has been done, what are the other necessary steps to register the beneficiary?
Great. So after that verification process has been completed by the company, well, the administrator here or the executor, as the case may be, may elect to have the shares registered in his name, or may direct the company to register those shares in the name of the ultimate beneficiary directly. So
Okay.
there are two options here, because once the company confirms that indeed you are the proper person to be dealt with, the proper administrator or the legal representative,
Yeah.
we can either register the shares in your name, so you subsequently transfer to the beneficiary because you are the one in charge of administering the assets, or you as the executor or the administrator may elect to have those shares registered directly in the name of the beneficiary.
Okay.
But I must emphasize again that it all starts with the company verifying the authority of the executor or the administrator, as the case may be, because that's the beginning of the entire process.
Right.
In some instances, once the company confirms that indeed the executor or the administrator is the proper person or has the requisite authority, the company may request the administrator or executor to either make that choice, whether to have the shares registered in his name or directly in the name of the beneficiaries. Depending on the choice that is selected, it doesn't just end there. Steps must be taken to properly register the name of the new shareholder at the company's registry from the ORC particularly. And then, of course, we know that it must be emphasized that you must issue share. The company will then go ahead, issue share certificates as well, which is conclusive evidence of the shares, basically, of ownership of the shares, basically.
Right. So whilst the company takes the necessary steps to register the beneficiary to take up the space of the deceased shareholder, do they have some rights or benefits? Melody, would you take that?
Yes,
do they have
I
some
will.
rights and benefits, and do they get to enjoy those rights and benefits?
Yes, they do.
Okay.
So before registration, the beneficiary is entitled to enjoy some of the benefits that accrue to every registered shareholder. I use the word some because there are exceptions, which I'll later on address. So some of the benefits or the rights that a beneficiary pending registration can enjoy include the right to receive dividends. And also, usually when a company is winding up, after payment of the debt of the company, the surplus of the assets of the company are distributed amongst the shareholders. Such a beneficiary will also be entitled to receive a share in this surplus asset. Now, let me address the exception that I spoke about.
Yeah.
And this exception is the right to attend and vote during meetings. So this is to say that beneficiaries pending registration are not entitled to attend and vote during meeting. And the reason is quite simple because first and foremost, their names have not been entered into the register of members. So they are not members so properly called. So they are not entitled to attend a meeting which is meant for members of the company.
But how is that fair? If you are enjoying all the money and the goodness that comes with it, why can't you vote in meeting? But I think your reasoning makes a lot of sense to me. So, what happens to decisions that were taken whilst the beneficiary was awaiting his registration? What happens if there's a liability from a decision that was taken in an AGM, for instance? Is that binding on the beneficiary, even though he or she did not really partake in the decision making?
Okay, so when it comes to the acts of members in a general meeting, if those acts are taken in accordance with the constitution of the company and all the applicable laws, such as the Companies Act, it constitutes a valid act of the company. And such acts are binding on all members of the company, whether you attended the meeting or you did not attend the meeting. So if such a decision or such act is binding on a member who is entitled to attend and vote during this meeting, then how much more someone who is not entitled to attend a meeting? So every decision which is taken pending registration is binding on the beneficiary. And also, I personally think it will be quite problematic if this is not so, because it will open up the floodgates for individuals to come in and say that the decision of the company is which were taken before their registration is not binding on them. It will lead to a whole lot of arguments.
Even sometimes you can sit in a meeting and not cast the votes, like abstain from voting, or you can have a dissenting view, say I don't want to, I want to vote B, but majority votes for A. And if there's a liability, you voting for B doesn't make you So that's really is something to also look at. So now, Audrey, we've spoken about the beneficiary having to enjoy some rights and co. What about liability? Does the liability of a deceased shareholder carry on to the beneficiary after his death, or once you die, that's it, your benefit, you go with your liability, or once the shares come with some sort of benefits, once you are enjoying the benefits, you also enjoy the liability?
Well, I'd say that it's more practical. Like in law, we say take your victim as you find him, because once you are registered as the beneficiary or you're registered as the shareholder of the company, following the entire verification processes and all that, you step into the shoes of the deceased shareholder. So you assume all duties, you assume all rights, you assume all responsibilities. So in the same way you enjoy benefits that are attached to those shares, in that same way, any liability that's are attached to the shares, you bear them as well. So it goes hand in hand. Once you assume that position as a shareholder of those shares, holding those particular shares, you step into the shoes of the deceased shareholder. So any rights and liabilities, you bear the full brunt of it. So yes, you cannot enjoy the benefits and say, okay, it goes hand in hand. So that's how it works.
So if a beneficiary realizes that no, this shares comes with a lot of problems, it has a lot of liabilities, I'm not interested, what happens? Can he say, okay, please do not tell the executor, please do not register these shares in my name? Or what's the dynamic?
Basically, if you have been registered as, you've now been registered as a shareholder, and then you come into the company and you realize that, okay, I'm not really interested in this company, I do not want to be a part of this company. I mean, my father bought it, he had his own reasons, I'm a Gen Z. This company, I don't know, I'm not comfortable with the practices or the systems or whatever it is. You have an option, actually. You can take steps again to transfer those shares to a third party, subject to any restrictions that may be applicable or imposed based on the company's constitution or any other agreement that may be enforced. So you have an option. You can choose to transfer your shares to
Right.
a third party, maybe to existing shareholders. It's your own. It becomes your own personal property, so you can do with it as you wish. So if you do not want to be a part of the company, you do not want to be a shareholder, you're always free to transfer the shares to
Transfer the
another
shares.
person. Yeah.
Right. So I've been wondering, right? In the case of a joint shareholding, is the surviving shareholder the recognized person, or how does that play out?
With joint
So,
shareholding, you know,
yeah.
it's very interesting because with joint shareholding,
Yeah.
upon the death of one of the shareholders, the shares are legally goes to the surviving shareholder. So legally, at the end of the day, the surviving shareholder will hold the entirety of the shares.
Oh,
so
really?
if you hold joint shares jointly with another person, you cannot mainly, because you don't know who is going to die first. But if you
Yeah.
if there's a surviving joint shareholder and then you pass on, your part of the shares cannot be passed on to your estate. At the end of the day, it goes entirely to the surviving shareholder. So that's the interesting thing about joint shareholding. Basically, it does not form part of the estate of the deceased shareholder. At the end of the day, the entirety of the shares will be held by the surviving shareholder.
My goodness. So if someone owns 10% shares, like a joint shareholding, right? Someone owns 10, and then he passes on automatically.
At the end of the day, the principle of survivorship kicks in legally. And so at the end of the day, the bottom line is that the entirety of the shares will ultimately be held by the surviving shareholder. So it cannot form part of the estate of the deceased shareholder to be distributed among his beneficiaries. So that's the legal principle. It just kicks in.
You know what? We will have a discussion about that later. But you know, with matters of shares, shares brings out a lot of issues. Example, beneficial ownership, right? So I'm wondering, what is the implication of beneficial ownership in relation to share transmission?
Okay. So, Olga, to answer your question, I think we have to understand who a beneficial owner is.
Yeah.
So, when we talk about beneficial owner, they are persons or individuals who directly or indirectly hold an interest in the company. Sometimes they may not hold an interest in the company, but then they may exercise some substantial control over the affairs of the company.
Yeah.
And when this happens, such persons constitute or are deemed to be beneficial owners. And the law, specifically the Companies Act, imposes an obligation on companies to maintain a register of beneficial owners. And the policy rationale, of course, is to help combat money laundering and the numerous financial crimes that we have around.
Yeah.
Also, the obligation does not end there. The company is also mandated to file beneficial ownership details at the office of the registrar of
Companies.
Yeah. And this obligation is dependent on whether the BO in question is a reportable BO or a non-reportable BO.
Okay.
So when it comes to determining whether a BO is reportable or not, there are thresholds.
Yeah.
But when the BO does not hold an interest in the company, but then they just exercise some form of control over the company, they're automatically reportable.
Okay.
But once they hold an interest in the company, there are thresholds, as I earlier on indicated. So when the person is a politically exposed person, specifically a Ghanaian politically exposed person, the person is automatically reportable.
Okay.
We are not concerned about the percentage of interest that the person holds in the company.
Yeah.
But then when a person is a foreign politically exposed person, if the person holds 5% or more, the person is reportable.
Okay.
But then in all other situations, like you and I, who are not politically exposed,
Hey, me, I'm a politically exposed person.
we must hold
Yeah.
at least 20%
Yeah.
of the interest in the company before we will be deemed to be reportable.
Right.
Now let's go to the real question. Let me now answer the real question.
Yeah.
That is the implication of transmission of shares on beneficial ownership. And to answer this, I'll use a scenario to address this question. So let's say Mr. A holds 5% interest in the company and he dies. And once he dies, his interests transmits or devolves by operation of law to his nephew, Kwame, who is a politically exposed person. So initially, because Mr. A was not a politically exposed person and he held just 5%, he's not a reportable BU.
Right.
But once the share transmits to Kwame, his nephew, who is a politically exposed person, then the BO in question becomes a reportable BO. And as such, the company is mandated to update the
records.
Its records reflect such
information
or such information.
Right. So in the case where let's assume that Kwame is the deceased person, right? Or Kwame is the politically exposed person.
He's a politically exposed person. The legal representative.
In this case, he's not a politically exposed person. He's a normal person who, just like, as you said, just like me, but he owns about he has about 10% interest in the company, right? And his deceased uncle holds about 15% interest in the company. When he also dies and, transfer his shares to his nephew Kwame, then it means that, from what you said, it means that he's reached the threshold. Is that not the 25% threshold? Yes. So then he has to also be reported as BO.
Exactly.
Yes. Yes. I like that. BO is a whole topic on its own, very interesting, and perhaps the team would attempt to have a discussion on that if you agree with me. Okay, so we've discussed BO, we've discussed how shares move from the executor to the beneficiary, or the legal or the personal representative to the exactly. We a lot has gone into this conversation today, and we get a lot of inquiries about this in the firm. If not for any reason, I know about 6 or 5 of those. Per your personal experience, and you work with the BSS team. We are all in the BSS team, the business support service team in the firm. So we handle these things. Per your personal experience, Audrey, I'll start with you. Tell me, what is the single most important thing you'd want families to, in fact, I'll give you companies and then you take families. So what's one okay, or you can choose whichever you want to choose, but just one important thing that families or companies should take note of during a transmission of shares?
For me, I think the most important thing, particularly for companies that companies must take note of, is the verification process. Because that's very, very crucial. Upon the death of a shareholder, the company will only recognize the legal representative, in this case, the executor or the administrator, as the shareholder in the interim. I think the most important thing that the companies must take note of is the verification process, to actually undertake extensive due diligence to confirm whether the person alleging to be the executor is indeed the executor, or whether the person alleging to be the administrator is indeed the administrator, confirming whether indeed the probate has been granted, whether the letters of administration granted by the court is actually accurate. Because there have been instances where you would realize that some of these documents are forged, and then you may probably go ahead and go and register. It's in it opens up a can of worms, and there are so many issues that the company is eventually slapped with, because the due diligence stage is the most important thing. As the company secretary, once these people present such documents alleging to be the executors or alleging to be the administrators of the estate, it behoves on you to conduct extensive due diligence to confirm, because at the end of the day, these are shares, these are properties, they hold some form of value. So you must take every step possible to ensure that whoever you are dealing with, confirming, getting the necessary confirmation, if it's going to the court, making the necessary searches, because at the end of the day, you do not want to be saddled with so many issues and then so many things, it rolls over. So I think that's the most important thing that companies should note. No matter how long it takes, I think it's in the best interest of all parties involved to ensure that whoever we are giving the shares to, whoever we are registering as a member or as a shareholder of the company, is truly the right person. So no matter how long these due diligence processes may take, I think the company has that duty to ensure that at the end of the day, whoever we ultimately deal with or register the shares for has that authority and is the right and proper person to benefit from the shares. So I think that's the most important thing that must be noted.
Fantastic, Audrey. Fantastic submission. Now, Melody, since she's done for the companies, you do for the family.
Exactly.
Okay, so let us know what you think,
Okay.
or per your experience, actually.
Sure. So my advice goes to the legal representatives of these deceased shareholders that pending registration, even when you've not been registered formally by the company as a member of the company, you are still entitled to receive dividends from the company. And as such, they must take the appropriate steps to receive the dividend that accrues to them.
That's the part that people would like to hear, because yeah. And I think from the discussion, one important thing for families to also notice is that automatically the beneficiaries are not recognized as the executors. So they have to give time and exercise a lot of patience when the executors are taking steps to register these shares in their name. Based on our earlier discussion, I just want you to give us a simple summary or advice Adjo Quarshie, who works up to a company, Fine Wine Limited, where her father held about 50% shares in that company. Following his death, right, he issues or he puts his shares in his will and says that Adjo should be the beneficiary of those wills, but of those shares. However, his executor is his brother, Wilson Kuma, right? And then Mr. John Kuma is the deceased. Please advise Adjo Quarshie how she should go about it if she shows up in the company and say, "Hey, you people, my father is dead. Mr. George Kuma is dead. I'm his beneficiary. Please take the necessary steps to register my name." How would you advise Adjo Quarshie? What should she do in this case?
Okay, so thank you very much. So as we discussed earlier, upon the death of a shareholder, the only persons who will be recognized by the company as the shareholders are the legal representatives of the deceased shareholder, which could be an administrator of the estate or the executor of the estate. In this case, George is dead. He left a will. He named Wilson as his executor. The first thing that must be done is the fact that Mr. Wilson must take the necessary steps to obtain probate from the court in order to administer the estate of George Kuma, who is deceased. Once he obtains the necessary document from the court, that in this case the probate, he submits the probate to the company. And in that case, as I earlier stated, the company will have to take steps to verify the authenticity of the probate to be sure that indeed Mr. Wilson is the proper person to administer the estate of George Kuma, who is deceased. Once the company goes through that verification process, confirms that indeed Wilson is the right person, George died, indeed he had a will, he named Wilson, Wilson has gone, the probate we have received is indeed authentic, is indeed proper, is indeed true or authentic, then there are two options available.
Okay.
Mr. Wilson can elect to have the shares registered in his name, since he's the administrator of the shares of the estate, following which he will subsequently transfer the shares to Adjo Quarshie. Or Wilson can just direct the company to register the shares directly in the name of Adjo, because at the end of the day, she's the ultimate beneficiary. So these are the two options that arise when that happens. But all, as I said earlier, it all starts from the verification process. Obtaining the probate, submitting it to the company for the company to verify, and then the options come in, whether to register the shares directly in the name of Wilson, who will subsequently transfer to Adjo, or just transfer directly to register the shares directly in the name of Adjo. So Adjo cannot just stand up and go and say, okay, my father is John, he died, he left a will, I know he had shares, these number of shares in Fine Wine Limited, I have come, give me my share certificate. I am the new owner of the shares. It doesn't work that way. You have to go through due process, and that's why we keep emphasizing about completing the due process, going through the requisite process to ensure that everything is done by the books. At the end of the day, it's in the best interest of everyone, and it prevents chaos, basically, because so many people coming up. At the end of the day, it makes things complicated. But at the end of, if we go through the right channels, go through the right process, it makes the process smooth and clean for everyone. So that is the advice to Adjo, and for the company, go through the right verification process to confirm who exactly you're dealing with, so that it serves all our interests.
Okay, so you're telling Adjo that go through your administrator to get this sorted out.
Yeah, go through your executor.
Yeah. Wow, understood. Melody, do you have any other thing to add up to what Audrey was saying? I saw you nodding your head. You are in full support of what she's saying. Do you have any other thing to add on?
She has said it all.
She has said it all.
There's nothing useful to add.
Okay. Thank you very much, Melody. Thank you so much, Audrey. Today's discussion has been very insightful. All too soon, the discussion has come to an end. I would wish for us to go on and on, but when you start to go on and on, you can never stop, right? So hopefully we will see you in the next episode of Community First podcast. My name once again is Olga Adjo Quarshie, a compliance administrator at BNP Associates. Thank you very much for staying with us, and see you in the next episode.